And so now at this point, I want to turn it back over to Peter for a few additional appraiser liability issues.
Okay, we do expect some liability issues to arise out of UAD and UCDP. We expect some positives and we expect some negatives. I will say right at the beginning, we think the overall net outcome for appraisers and AMCs is going to be to lessen liability risk when the whole project is fully completed. So for appraisers, we do think that there is some risk that some appraisers may fall further into the trap of the form-filling mode of doing appraisal work. And that's just because things like drop-down menus may lull some appraisers into feeling that that's all it takes to complete an appraisal report. Now, that's not the intention of UAD, of course, and in fact, I think the intention of UAD is really to break appraisers out of that mode by forcing them to use more descriptive terms in those drop-down menus. But what form filling does is that it takes the appraiser out of that analysis mode and leaves the appraiser providing no analysis in the report, and also failing to provide any additional commentary on important aspects of the property that they are appraising. So it's the failure of an appraiser to explain particular property issues in plain English in report comments or addendum that really leads to many of the borrower-type claims that we see against appraisers and also AMCs. It's when the appraiser actually uses plain English to discuss something in an appraisal that is a particular effect on that property, say that the property backs up to a glass bottle recycling plant, well, that needs to be said in plain English if the appraiser wants to escape liability, potential liability for failing to disclose something like that in a report. Now, form-filling mode simply creates reports that cause more appraiser liability, so we do see that as a possible risk, probably mostly short-term, for some appraisers. Now, for appraisers who don't fall into that mode, short-term, we expect that there will be some more borrower interference after reports are delivered, and that this could lead to more complaints being filed against appraisers, both in some lawsuits and in state board disciplinary complaints. And I think really that this borrower interference is going to arise from a misunderstanding by borrowers of some of the technical terms that are being used in the drop-down menus, and also some arguments with borrowers about the application of those particular terms. For example, that whether a home has 2.1 baths or 2.2 is going to be a mystery to a lot of borrowers and may cause some arguments with them. And then other things like when a house was originally constructed in 1930 but then was extensively remodeled in 2010, well, under the UAD parameters, the appraiser is going to be needed to identify the construction date as 1930. And when a homeowner sees something like that in an appraisal report but knows their home was extensively remodeled, they may have a complaint or a grievance with the appraiser, unless the appraiser uses some good plain English at the back of the report or in commentary to really explain the true situation with that appraisal. Now, long-term, however, we expect reduced potential liability due to the evaluation of appraisals being done by Fannie Mae and Freddie Mac and also FHA pre-funding. That's the critical key here, is that these appraisals are going to be looked at before loans are funded at the time that the mortgage paperwork is delivered to Fannie Mae. And so there will be the opportunity there, once the project is fully implemented, for simply defective appraisals to be rejected at that point before a loan is funded. And this would mean we will not see the same extent, hopefully, of the mortgage repurchase problems that are plaguing lenders and then trickling down to AMCs and appraisers. So for good appraisers, we expect the net outcome of UAD and UCDP will be a decrease in liability risk. Now, for appraisal management companies, they'll get some of the trickle down from the appraiser issues that I spoke about. And I think that we'll see increased liability exposure for AMCs if their panel appraisers fall further into this trap of form filling. And I have to say that based on the claims that we've received in the last 4 years, it is generally true that AMC panel appraisers are more prone to the form filling mode than appraisers who work directly for lenders. So this is a special issue that AMCs need to pay attention to if they want to prevent that trickle down of liability to them. Now, we can expect that some AMCs will see some additional liability on the representations and warranties that they make to lenders in their service level agreements and vendor contracts. And this will be because initially there may be reports that are rejected because of UAD problems, or as we get into the actual analysis of the reports itself upon submission through the UCDP, there may be some rejection of reports at that stage. And those AMCs that are delivering reports that get rejected, of course, will have some liability to their lender clients under the representations and warranties that they make to their clients. And so AMCs really need to pay attention to getting their appraisers, their panel appraisers, up to speed on UAD if they want to avoid these kinds of liabilities. Not to mention that it'll have a big business impact if a particular AMC has a greater share of rejections than other AMCs. Now, besides that, we do also expect some increased liability exposure to AMCs due to the fact that as part of this UAD implementation, appraisers are now going to be required to actually put the name of the AMC to identify the AMC near their signature on the appraisal form. I think Bill showed you a slide that showed where the AMC will be identified, and Fannie Mae makes this point clear in a fact that they issued with their UAD information, and in that fact, Fannie Mae said that the AMC must be reported on page 6 of the appraisal report in the name field under lender client. So it's just that increased visibility of the AMC in the report itself that will lead to more claims against AMCs. When borrowers and their attorneys see another party like an AMC in an appraisal report, they know that there's another target of a potential claim there. And of course, this liability exposure goes along with the additional liability exposures that AMCs are encountering because of their greater visibility due to AMC laws and registration requirements. So, to sum up some of the prevention advice that we have for our appraisers and for our AMC clients at this time, we think that reports really need to make strong use of additional comments and addenda to explain in plain English any unique issues that affect a subject property. Those are the keys to avoiding borrower liability claims. And as I mentioned at the beginning of my part of this presentation, greater than 50% of claims against appraisers and AMCs start with borrowers. So it's important. And it's also important that appraisers also avoid canned phrases in these comments and addenda when disclosing unique issues affecting subject properties. Now, reports also need to use additional comments and addenda to explain when UAD terms may not fit a situation properly. There are terms in UAD like waterfront that may need elaboration in additional comments. For example, if the property is canal front or beachfront, that might be a situation where the appraiser really needs to provide some additional information in commentary and addenda to make sure that the report is not misleading.